Hi, my name is Lizzie Chan, and I'm a member of the CPR Institute, Young Leaders in Alternative Dispute Resolution. I am delighted to host today's episode of the Y-ADR Corporate Counsel interview series. Y-ADR seeks to educate the next generation of leaders on the full spectrum of dispute prevention and resolution mechanisms, and to provide an insider's view into how CPR's community of in-house counsel, law firm counsel, and other experts in the field are using dispute prevention and resolution techniques to manage conflict to enable purpose. As part of this goal, in this interview series, we will be asking corporate counsel to share best practices in alternative dispute resolution and to share their advice for young practitioners. I am delighted today to welcome Karl Hennessee, who is the Senior Vice President, Litigation, Investigations, and Regulatory Affairs at Airbus, based in France. Hi, Karl. We're so happy to have you today. Thank you so much for your time.
Thank you, Lizzie, and thanks to you and to CPR for inviting me. It's a delight to be here.
My first question for you is, what is your role at Airbus and what are the types of disputes that you manage?
Well, if you think of a traditional division of legal services within any company, of being, say, corporate lawyers who create the infrastructure and environment for a company to operate, commercial lawyers to handle the relationships to suppliers, customers, etc., you can think of my role as being almost everything else. In other words, what's delightful about my role is I get to look back 50 years to the origin of my company and try to explain, defend some of the decisions we took in the context of disputes that may arise, more particularly trying to put the relationships back on track and looking forward another 50 years with partners with whom we have then reinvigorated our relationship, and perhaps using my regulatory hat in order to anticipate and drive some of the innovations that will serve our customers for the next 50 years.
It's so interesting that in your role, you wear these different hats and have different tools at your disposal. So focusing on ADR, what are some of the ADR tools that you've found to be most effective for resolving or avoiding disputes?
Well, any given tool has to be evaluated against the context in which it's being applied. No one tool will be right in all cases. My favorite tools to use are mediation and institutional arbitration. The reason is that I believe that mediation, coming at the right point when the parties are ready to discuss in good faith and find a solution, even if they violently disagree about what that solution may be, and institutional arbitration being the best compromise between the flexibility that arbitration offers and the need for some framework in which that to effectively and efficiently operate, are probably the two tools that I go to the most.
So you mentioned mediation, arbitration, two different tools that you might employ to resolve a dispute. So I'd like to now ask you a question about the drafting of dispute resolution clauses. What factors do you normally consider in drafting one, and would you include, say, both mediation, arbitration, or a mixture?
I'm not a fan of tiered clauses. I am a fan of simplicity. It's interesting that one of mediation's fiercest advocates does take the position that I hesitate to write mediation into a clause, because I find from experience that a tiered clause will often place mediation at the outset of a dispute when that may be the point where it is possibly the least effective. Often, the progress of a dispute can allow the points of view of the parties to develop to a point where mediation is actually timed better in the middle of a dispute, maybe even at the end of a dispute. I've had successful mediations even post-award that went extremely well because the parties had had the opportunity to challenge each other. So I will say this, I am always looking for, and I require that those who work for me look for opportunities that mediation may work, but I will not defend the idea that mediation should be a mandatory element of any dispute, much less in a contractual sense.
And focusing a little bit more on dispute resolution clauses, if you have an arbitration clause, do you have a preferred or default seat and governing law?
Not so much a default as maybe a set of choices that we believe reflects neutrality. The most important criterion that I look for in any clause, and really in answering any question about the context of an arbitration, is, and that's for two good reasons. The first is, I believe that the purpose of the dispute is actually to put the parties' relationship back on track. Nearly all ADR is between parties that have a past and deserve a future. The second thing is that at a fundamental level, a clause or a choice within any ADR context that deprives one of the parties of the sense that it is fairly treated will inevitably leave them feeling sour on the result and therefore make it more difficult for them to get back to business together. And so I do have a set of choices that I prefer, and these are seats where there is an established law that is perceived as fair and balanced and impartial, institutions that meet the same criteria. But beyond that, I try to make as few mandatory choices as possible in the early stages, especially at the contractual stage, because I believe the flexibility of arbitration deserves that the parties are given an opportunity to, within a simple framework, in a short clause, then maximize the flexibility to focus on the dispute as it exists at the time it arises, rather than at the time it's anticipated, perhaps many years before in a contract.
You mentioned before that you're a fierce advocate of mediation. Can you tell us a bit about your experience with effective and maybe less effective mediations?
Well, I'll give you two examples, a very bad example and then perhaps a good one to follow. The very bad example concerns the very first mediation in which I was involved as a very junior associate at a large international law firm. When on a Monday, I was handed a file for a client and told by the senior partner that I would represent that client on the Friday to follow in a mediation. So I worked very hard all week. And on Thursday evening, I went to see the senior partner to debrief before the mediation, as he wasn't going to be there. And before I had any chance to ask any questions at all, he said, I have only two questions for you, and then you're going to go off and do this. The first question is, do you have a thick file? I said, well, yes, I do. Here's this lever arch file that I've carefully prepared. No, you don't have to show me. Second question, do you have a thick book? I said, well, what do you mean, sir? He said, well, like Moby Dick or War and Peace. I said, I don't understand. He said, well, it's very simple. When the mediator's in the room, you're to be reading the thick file. And when the mediator is not in the room, you're to be reading the thick book and definitely not billing the client. It set the stage for every single disappointing mediation that I've ever attended, regardless of my own client's status in the mediation, in the sense that it taught me in that one lesson how ineffective mediation can be if either of the parties is not prepared to attend with an open mind. And to turn to the question of a good example, I've seen mediations between parties who truly, truly disliked each other work wonderfully well as long as two basic criteria were met. The first is each party actually wanted to be there. For whatever reasons, they wanted to be in that room. And the second was you had a talented mediator who could discover the reasons each party had for being there and bring them together, because even if they didn't like each other very much when they left realizing that something magical had happened, that someone working in the mediation process had helped put their commercial relationship back on track and get them past a problem that had stymied the development of what they might do otherwise.
You play such an important role as in-house counsel, to guide your company to the resolution of conflicts. And I was wondering, how is your legal department structured?
Well, it's a team effort. I'm flattered that you consider my role very important, but it's no more important than that of any of my colleagues. We're a rather traditional structure for the most part, in the sense that we have a head of corporate affairs, we have an intellectual property specialist team, we have a commercial team, with some slight differences. We have an international legal department, which is then tied into all of those specialist areas, but is managed by an individual who oversees the countries outside of the four core European countries that founded Airbus, as well as also product specialist general counsels who serve the division's interests in the same way.
Is there anything you think that external counsel commonly misunderstand about in-house counsel, or that you think they would do well to appreciate about in-house counsel?
I think it's possibly a combination of underestimating and overestimating in-house counsel. I think they tend to underestimate in-house counsel's level of experience because we don't speak with the same fluency in the vocabulary that they generally use. And therefore, they don't tend to appreciate just how much experience many in-house counsel actually have in disputes, because they're not necessarily speaking in terms of subparagraphs of this or that set of institutional rules. And yet, at the same time, they may overestimate an in-house counsel's ability to focus on a single matter, especially a dispute matter, in the same way that they're able to do, because we will be handling at any given time dozens or even hundreds of disputes, whereas I've never met an outside lawyer who was working on more than 6 or 7 at the same time.
Wow, you manage so many disputes at any one time. So I think you would want to have very good external counsel. So what do you look for when you're hiring external counsel?
More than anything else, I want to know that that external counsel is always going to speak her mind. I mean that not just in a literal sense, I mean that in every sense. It's the criterion by which we select our lawyers. It's the principle that I reinforce each and every time I introduce a matter to them, and even along the way. And no one in my team, be it my secretary or my outside counsel or my most senior management team, are doing their jobs if they are not actively disagreeing with me. There's a famous quote from the founder of Google who said, if you think you've got a great idea, put it on a pedestal and invite everyone you know to throw rocks at it. And if it survives, it's truly a good idea. The role of my outside counsel is to throw as many rocks as hard as they can, so that what we emerge with is a collaborative strategy that actually survives the test of the real dispute.
In the short time that external have to pitch to you, how can external counsel distinguish themselves?
I think in addition to focusing on what I've just said, don't tell me why I win. Tell me what's risky. Tell me what's dangerous. Tell me how to manage the risks that you see that I've missed. Don't express great confidence in my case. Tell me what's wrong with it and what we can do to make it better. Tell me I should settle rather than fight, if that's what you believe. That's one part. The other part is I want to see and know the whole team. There's nothing that irritates me more than seeing a panel of senior people on a pitch document with eye-popping hourly rates whom I will never see again, and then having all the work done by a team that I think is wonderful, but I've never met and I didn't actually select. And so what I like and what I even insist on is show me the team that's actually going to do the work, and not just the partners, not just the counsel. I want to meet the paralegal. I want to meet the associates who are going to be spending their nights and weekends working hard for me, because I want to know who they are. I want to know what their ideas are, and I want them to feel comfortable that they can call me or anyone in my team, that they don't have to follow a channeled hierarchy, because that's not the way we operate. And if we did, I probably wouldn't hear about their good ideas, and I'd rather like to.
I think that many of the young practitioners tuning into this conversation will feel very heartened by what you said and your recognition of their work. We've now lived in this pandemic period for, I think, over 1.5 years now. And has the COVID-19 pandemic changed or not changed the way that your company manages disputes risks?
It hasn't changed terribly much. I think that the essence of the advice we've always tried to provide was that of resilience and survival. So if we compare the COVID-19 pandemic to SARS or to the crisis in aviation following September 11th, or perhaps even the financial crisis, one can draw distinctions between how it happened. But in terms of the way the company needed to react and the types of disputes that follow any interruption in a business cycle, frankly, we learned a lot from those previous crises that we were able to apply and perhaps even enhance in the period within COVID-19. The story isn't finished. There's more to be done as we emerge from this crisis. And I think we'll continue to play the same role we always have, which is to look for ways of putting relationships back on track that may have been interrupted by something that happened, either an exogenous force like COVID-19 or something endogenous to the dispute, which is more the bread and butter of what we do every day.
Before this interview, we chatted about your personal connection to Hong Kong, which is where I am now. So I wanted to ask you a little bit about your connection there. So about 2 years ago, you gave a keynote speech at Hong Kong Arbitration Week on the topic of arbitrating for settlement. Can you tell us a bit more about that?
I mean, really, just to answer your first question first, I love Hong Kong. It's one of the world's greatest cities, and I've always felt a personal connection, though I have no experience living in Hong Kong or growing up there. I've affiliated myself with a lot of things in Hong Kong and institutions in Hong Kong, people in Hong Kong. I have many good friends there. As you mentioned, I serve on the council of the HKIC. I serve on the board of a couple of companies in Hong Kong. I teach on occasion at Hong Kong University, and I've always admired the spirit of the people of Hong Kong, perhaps as much as any I've ever encountered. In terms of the speech I gave, it was a great honor to be asked to give that keynote speech, both because it was on a topic I really care about, structuring arbitration in order to design opportunities and encourage settlements as opposed to prevent them, as well as also the fact that it was Hong Kong Arbitration Week, where I find some of the best minds come together to debate questions like just the ones we're talking about.
It's so wonderful to hear about your connection to Hong Kong University, which is where my mom did her law degree, and she was pregnant with me when she went to law school.
Sounds like you picked up a lot even early.
Another connection you have to Hong Kong is that you serve on the HKIAC Proceedings Committee. Can you tell us a bit about your experience?
Sure. In simplest terms, it would be too easy to boil down the work of the Proceedings Committee to rules interpretations. But that misses the point of why the HKIC has established a group of some of the finest minds I know in arbitration to deal with what seem like rules disputes. It's because those rules create the architecture, the infrastructure, even the guiding space of why parties choose arbitration as a means of dispute resolution. And it would be too simple to say that it's a dry rules interpretation when in fact it's the policy behind those rules and the consciousness of the members of the Proceedings Committee that these interpretations matter as a question of credibility, not just for the points that are being resolved by the committee at that particular point, but as to the outcome. And that an interpretation that is seen as fair and as having been made by the fine minds who I'm privileged to call my colleagues on the Proceedings Committee will drive a real acceptance of the outcome of an award that might otherwise be denied, and therefore an opportunity missed for the parties to put a relationship back together after that award is issued.
Before this interview, we talked about a recent paper that you wrote about innovation and some comments you made on gender diversity. Could you tell us some key points from that paper?
Sure. That paper was a bit cheeky. It was essentially something I published in the journal about 18 months ago, and it was a candid assessment of both the idea of innovation in international arbitration, as well as also some of the innovations that had been pitched by various institutions. And the two conclusions that I came to is that given an inherent conservatism in arbitration, there is really nothing in recent years that meets the technical definition of innovation as being something explosive that completely changes the trajectory. And perhaps that's actually a good thing. And the second, and I think probably even more important conclusion that I drew, is that the only unalloyed good that I could find among the many innovations being touted by institutions was a drive for diversity. And I say that both because it is a moral and ethical imperative, but also everything I know about social science, which is a bit, since I studied econometrics and industrial organization before I went to law school, says that more diverse groups of people, whether it's groups of counsel or group or tribunals, et cetera, make decisions that are objectively better. And I can honestly say from my own experience that some of the least attractive decisions that I've seen in terms of the quality of the award and the reasoning and the acceptance by the parties, regardless of who won, were made by very homogenous tribunals. And as a consequence, I'm a fierce advocate of diversity. and embrace any initiative that's going to help us achieve that on an ongoing basis within ADR.
I'm really heartened to know and hear about your experience as a champion for gender diversity. It's an issue that's really close to my heart as well. And I've been, over the past few years, been working very hard through Arbitral Women and the Equal Representation and Arbitration Pledge Young Practitioners Subcommittee on taking concrete actions to raise the profile of women and to get more women appointed to tribunals.
Something I believe in as well. I serve on the corporate subcommittee supporting the pledge.
Oh, wow, that is wonderful. Thank you so much. I'd now like to pivot to some career-related questions for the young practitioners in our audience. And one is, what is your advice for young practitioners who may be external counsel who are looking for an in-house career?
I think it can be summed up in 2 words: do it. That's perhaps overly simplistic, but having served as a government lawyer, both in Europe and the United States, having practiced in law firms, both in the US and in Europe, the decision to move in-house was one that I approached with a bit of trepidation, and ultimately embraced because I was so excited about the aviation practice that it would mean for me. And I found in the years since that there are really sort of 2 things that I genuinely love about it. The first is a true risk management mentality. It's almost impossible as counsel within a law firm, even at a very senior level, to adopt the same kind of portfolio type approach that I can to my disputes. In other words, I can see things as a whole that are rather difficult for a law firm partner even, who has 5 or 6 ongoing matters at any given time. I have hundreds, and therefore I can see a bigger picture that really does help me manage risk in a way that I think is most effective for my client. The second thing is, to be honest, there is something really special about my day when I take a step back at it and I can look beyond the irritation of having meeting after meeting after meeting and look at what that represents. I may spend one part of my morning dealing with a products case that takes me back to one of our earliest products 30, 40 years ago, meeting some of the founders who created the company. And that may be immediately followed by talking to a technology team about a regulatory problem that presents an opportunity for us to build something that will carry passengers into the 2070s and beyond. And that, I think, is unique enough in that I would struggle to give it up, even if I had the opportunity to embrace some of the things I did love about being with a law firm, and perhaps the thing I love the most, which is advocacy.
It's so exciting that you have like such comprehensive knowledge of all the different aspects of your company's business. And one question I have, sorry, did you want to comment?
No, I wanted to say that with all humility, I don't think I have comprehensive knowledge. And one of the things I like the most is that I have the smartest clients in the world to teach me anything I want to know about the things that I know far too little about.
And on the subject of learning, what can junior and mid-level associates do to better know the client company and the commercial priorities? And I ask that because the way that a lot of law firms and teams are structured, I think communication is often channeled through the partners or through the counsel or senior associate. And junior mid-level associates might be too scared to reach out to the client. So what's your advice for practitioners at that level?
I would say break the mold, because we in the client's world don't believe at all with the idea that clients' communication should be channeled through the senior partner, especially those of us who were young associates. We know that the people who know the most about our case, who are working hardest on our case, the ones who essentially can actually answer the questions I probably have, are not at the senior partner level. And if they are, the only reason the senior partner has that information is because it's been carefully researched and prepared by a team of people who are supporting him or her. And so the advice I would give is, don't hang back if you'd like to know more about what we do. I'm always surprised when I speak at conferences that the people who come up afterwards to see me are the senior partners with the business card who really are not any more interested in who I am or what I do than the opportunity for business I may represent. And that the people who essentially are just genuinely interested to know about my point of view or what my company does, they don't necessarily come up and ask because they're afraid of the hierarchy that you've just described. And I would say the one get out of jail free card that you will always have if you break the hierarchy is the client, in the sense that if a client actually asks to speak to you, includes you in the discussions and the debates, values your opinion and your advice, then no senior partner on the planet will ever interfere with that, no matter how strict the hierarchy. But the only way that I will know who you are and the value of your opinions is if you make yourself known to me. And so I often find it's a pity that more junior lawyers will never reach beyond a simple LinkedIn request and will never follow up to actually ask the questions that, frankly, I'd like to hear about because I'll learn something from you when you ask it.
Thank you so much for encouragement for the young practitioners among us. And thank you so much for taking the time to chat with me. I have learned so much from the questions that I've asked you. So thank you again for your time, Karl. And thank you to our audience for tuning in.
It was my pleasure and my privilege. Thanks to you, Lizzie, and to CPR once again.